Hi, everybody, and welcome back. So today we're going to be talking about the proposed rulemaking that I'm sure you've heard of from CMS having to do with future medicals and the Medicare secondary payer obligation. So we know pretty much, if you've been paying attention to my channel so far, that basically what they're talking about is on third-party liability cases. Is there a requirement in order to save or set aside some money from a third-party liability settlement in order to protect Medicare secondary payer rights? And, the concept is pretty straightforward. Your client was compensated for their injuries that would otherwise be Medicare allowable. And instead of passing those bills, those future bills, onto Medicare, the question is how much of your settlement should be set aside in order to pay for those Medicare bills. Okay. Assuming that they've been compensated for their injuries having to deal with the settlement. And we've talked a lot about why, those laws are in place, why, Medicare has the right to do so. And the one big major fact that we keep coming back to is that Medicare really doesn't have the facilities or the capability to enforce those, even though the law is in place and the claimants, arguably have an obligation to set aside funds from their settlement. Very similar to the workers' comp arena. And if you go back to the Stalcup memo, it says that there's no distinction in the law that differentiates between workers' comp settlements and liability settlements. And to me, it seems pretty straightforward. If an insurance company or a defendant was, paying or compensating for future medicals, why then should the claimant be cost shifting that back to the public trust fund for Medicare? So in the coming weeks leading up to October, when that announcement is going to be made and the guidance is going to be given, hopefully, we're going to be talking about the different things that CMS has been doing to ramp up their abilities in order to, seek subrogation for those settlements. And if you want to stay tuned, or feel free to give me a call and I'll help give you some insight and show you some of the evidence and the proof, if you will, as to why we feel this way. Just reach out. I'm happy to help out. So until then, stay tuned for the future videos where we talk about some of the different contracts, for example, that have been expanded in order to compensate for the review of thousands of more cases coming up. And hopefully by the time we're done vetting out all of these issues, it'll be October and we'll either find out the new guidelines that are coming out, or they'll have moved the date to next year sometime, or potentially in March, as they did before COVID, that they were, 18 months ago, they had announced that they were going to provide some guidance on this issue. So until then, I'm Joe Calentino here with Plaintiffs MSA and Lien Solution. And feel free, if you want to set up an appointment to have a conversation or to triage one of your cases and discuss maybe doing a analysis on your case. There's a Calendly link right at the bottom of this video. And until then, see you next time.